to all of you on behalf of Ministry of Education's Institutions Innovation Council, Modern College of Arts, Science and Commerce, Shivaji Nagar, Pune. For today's event, we have with us Vice Principals of Modern College, all the teaching staff members, the students, and IIC members. As a resource person for today's talk, we have with us Dr. N.B. Dahibhate, sir, who has over 40 years of rich professional experience working in Special Library, Information Center, and Digital Information Resource Center. Sir has retired as Principal Technical Officer, CSIR, National Chemical Laboratory, Pune. Before we start, there is an announcement. There is an announcement for all the participants that a link will be shared on the Google Meet chat regarding the feedback, and it will be shared on the YouTube also. So certificate will be issued only to those students or only to those participants who fill this form. Now I request Dr. Santashri Sengupta ma'am to introduce today's speaker.
Good afternoon, respected authorities of the Progressive Education Societies, Modern College of Arts, Science and Commerce, respected Principal Dr. Rajendra Zunzar Rao sir, all Vice Principals, IQAC Coordinator Dr. Anjali Sardesai Madam, who is also the President of the Institution Innovation Council, all the head of the departments, teachers, the UG and PG coordinators, members of the Institution Innovation Council and IDEA I3 Club, and our dear students. I feel honored to introduce my teacher, Dr. N.B. Dahibhate sir, for today's mentoring session on intellectual property rights. Dahibhate sir has a total professional experience of 45 years, and sir was working as Principal Technical Officer in CSIR's National Chemical Laboratory, Pune. Sir is a PhD in Library and Information Science field from University of Pune, and his research topic was Patent Literature in Chemical Sciences, Analytical Study of Selected Countries. Dahibhate sir's research mentor was Professor Dr. Suresh Patil sir, who was the librarian and head of the Department of Library and Information Science in University of Pune. Dahibhate sir has been ardently involved in developing information centers and digital libraries with his experience in providing reference service, referral service, and information services. Technical and consultancy services has been provided by him to specialized users in chemical, pharmaceutical, and natural sciences, as well as in industries. Sir has been functional in providing patent information and searched for prior art and full text patent documents using many national and international patent databases. Dahibhate sir, in the year 2000, has done a 6 weeks online course in intellectual property, which was organized by the world-renowned World Intellectual Property Organization, that is WIPO, which is in Geneva, Switzerland. He has been associated with several universities across Maharashtra as a guest faculty and adjunct professor. Sir is a member of learned societies like Indian Association of Special Libraries and Information Centers, Pune University Library and Information Science Alumni Association, Society of Information Science, New Delhi, Indian Library Association, New Delhi, and Special Libraries Association, United Kingdom. He has a very rich professional experience, which is getting continued even till date. Sir has been functional in developing the libraries which had just now started functioning. He's still continuing helping his students like me to enrich their educational as well as professional experiences. Sir has received coveted awards like Shri Ananta Narayan Gore Award for merit list in during his Bachelor of Library and Information Science course from Marathwada University, which is now known as Baba Saheb Ambedkar Marathwada University, Aurangabad. He has received the Granth Mitra Puraskar awarded by Parnerkar Maharaj Granthalaya and Public Library, District Ahmednagar. Sir is the recipient of Certificate of Excellence Award in recognition of his exemplary contributions in the area of library and information science from Gulbarga, Karnataka. The list is endless. These were just some of the awards that I mentioned. He has visited several foreign countries for his professional work. Some of the countries like USA, UK, Paris, Spain, Switzerland, then the Gulf countries, then Singapore, Malaysia, all these countries Sir has visited. And Sir has published several books as well as several research papers in national and international conferences. Then he has been associated with well-renowned international publishers also. Sir is a PhD research guide in Tilak Maharashtra University, and he is also associated as a member as well as writer for the textbooks in library and information science with the Maharashtra Textbook Bureau, that is well known as Balbharti, Pune. With an unending list of the professional achievements and highly impressive work that is done and is still getting done by my teacher, Dr. N.B. Dahibhate sir, I now request him to guide us and share his knowledge in the topic of intellectual property rights. Over to Dahibhate sir.
Thank you, madam. Nice introduction.
Thank you, sir.
All the authorities of modern college, especially Dr. Mrs. Sardesai madam, President of IIC, Dr. Junjar Rao sir, Principal of Modern College, of course, convener of this main function, Pardeshi madam and Sen Gupta madam, and all the participants of today's webinar. I just say good afternoon to each and everyone. In fact, I just load my PPT and then we will continue our today's session. Can you see my PPT and listen to me properly?
Yes, sir.
Yes, sir.
Okay. So very good afternoon to each and everyone. In fact, today's session, as initiated by Dr. Sen Gupta and Mrs. Sheetal Pardeshi madam, it is a just awareness program, we can say, where we can have a general awareness of IP, IPR, its types, their technical aspects. And today's need is that we should just have good rapport with the IPR. So whatever new ideas, new innovative concept we have developed, that should be protected by IPR. Okay. Intellectual property protection is now necessary to enhance innovative ideas for use. Without protection of ideas, business and individual would not get the full benefits of their inventions, and they would focus less on research and development. If we don't give them some proper judgment for their innovative concept, then very less interest will be developed. And the main aim of this IP is that whatever we are developing from our experiences, it should be shared among others also. It should be protected by law for getting some revenue benefits and some monopoly rights for using that property. There are many terms, very well-known terms used in this today's lecture, especially IP, IPR, IP laws, legalities, that we are going to look into this. But nowadays, earlier industries were very popular in filing all these intellectual properties. But now universities, public research institute are also directly contributing innovative and research activities in the society. All the youngsters, they are now publishing many articles, they are developing new concepts, they are writing, they are conducting research, and many intellectual properties are being generated by the youngsters. But only thing is that there is no awareness for how to protect these proper these intellectual ideas, intellectual output in the way of intellectual property and by protecting the law IPR. This is a just a small initiation that we can get some overview of IP and IPR. Since May 2016, National IPR policy have been approved by Union Cabinet, which is the first ever IPR policy framed by Government of India. And the main important thing of this policy or aim of this policy is that to develop awareness of IP and IPR at all level of information society, including common man. Similarly, many organizations are now after just conducting many courses on IP and IPR. First of all, we will look into few aspects. What is IP and what is IPR? It is rightly said by Land in 1976. The only thing keeps us alive is our brilliance, and our brilliance is protected by the patents. Means whatever intellectual property we are generating from our brain, human mind, human brain, that is to be well protected by some legal issues, and that is why IP, IPR we have to take some initiative. Now, what is intellectual property? Intellectual property refers to creation of human mind. Whatever we think, whatever we develop, whatever we share, if it is a new one, new concept, which are coming from our brain, like inventions are there. Somebody writes books, literature, some artistic works, some industrial designs. Then somebody uses symbol signs for trademarks. Then many images, designs, crop protections, all such type of intellectual property, what is generated by various means, by different expertise in the society, that is to be called as intellectual property. In brief, they have said that intellectual property is nothing but whatever thought we have generated in our mind and coming from the brain, and we are activating it in the in our experiments and all these things, and then some new concept, new ideas have been generated, and they are to be well protected so that whosoever is inventing, he will get some benefits, both moral benefits as well as financial benefits. Of course, we know properties are of two types. One is tangible, which we can see, and another is intangible property. Tangible property, it is, that is movable, immovable property, everybody knows that. But intangible property is also many times called as abstract property, which we cannot measure, which we cannot see. And such properties are covered under the intellectual property, which is developed by the human. Then intellectual property is also divided into two. One is literary and artistic work, that is copyrighted work, and second is industrial property. Copyright deals with writing, art, drama, culture, music, etc. Whereas industrial property, which is originating or generating from the industries, like patents, trademarks, service marks, trade secrets, geographical indications, layout designs, semiconductor of IC, plant varieties, and industrial design. These are covered under the industrial property. IP is expressed ideas. What is IP in nutshell? They have mentioned is that IP is nothing but expressed idea, which is coming from the human mind and protected by law for certain period. Of course, its period may be different to different property, but for gaining economic benefits to the creator of the property. The role of intellectual property is to generate economic rights to creator, commercial exploitation of creator of IP, so that he can go into the market and sell out his invention outright or give some licensing to others. Then it is useful for transferring the technology at international level. Economic growth of the country also depends on the intellectual property growth. Basically, IP support many aspects like creation of knowledge, innovative concept generation, commercialization, or putting the ideas into business and make finance out of that, protection and enforcement in the society so that this intellectual property can be used for the improvement of the society and benefit of the society. Now, what is intellectual property rights? Intellectual property law developed to reward innovators with some type of limited property rights. They may be, why we say limited, it has some fixed boundaries so that whatever we have generated from our mind, it is to be protected by law, and that law is called as intellectual property law. Due to this law, the property is protected for a certain period, and in that period, the creator will get some benefit of financial aspect. So intellectual property rights provide protection for creation and inventions to enable creator and inventor to earn recognition also, financial benefit also, and his work will be developed by others also, and the knowledge will grow on the knowledge development. Rights relating to protection of intellectual property are called as intellectual property rights. Intellectual property rights are legal rights. They are issued by government, given by government, and they are resulted from the intellectual creation of anyone. Either it is coming from industrial sector, it is coming from scientific sector, literary or artistic field, but whatever new ideas, new concept, new literature, new drawing, new design, whatever new coming which is not known to the society, they are protected by intellectual property rights. The rights are granted by state to the creator, and that is why it is very important, and it has some protection at the higher level, and whatever incentive or inventive creations are created by the property developer, then they are getting some rights out of that, and these rights exclude the unauthorized and commercial use by any other unless and until they are getting permission from the creator, either by means of sharing some royalties, sharing some license fees, sharing some MOU, or fixing certain amount with them. So it will be a good for his knowledge. Whatever he has generated, he will get reward for that. The individual or company holding the IP rights is known as right owner or right holder of the intellectual property. And this right owner or right holder of the intellectual property, he can develop new ideas, or he can sold his invention to others for certain period till the invention is on his name. But once the invention went into the public domain or goes into the public domain, then anybody can use it only in the terms of citing them who had first creator of this thing. The main aim of the IPR in the world is to enable people to create new knowledge. The reason for creating all these intellectual property right is that creator should create new knowledge that should be protected, that should be used properly, and for this purpose, the creator will get some financial benefit out of that. TRIPS agreement, that is trade related aspect of intellectual property rights, in 1994, they have provided worldwide uniform system for protection of intellectual property, and they have fixed the certain boundaries, certain intellectual property which comes under the IPR jargon. First of all, it is patents. Patents deals with novel and new inventions. Whatever new is coming in the market, new is developed by the creator, inventor, assignees, that is protected under the patent. Trademarks, which are dealing with the sign symbols, which are particularly used for identifying goods and services from others and getting benefit into the business area. Geographical indicators, they are dealing with the origin of the good and services for promoting commerce and trade and preserve the culture available at that particular place. Industrial design deals with aesthetic creation, that is beautification and all these things, and related design, which is totally new to the society. Trade secret, of course, it is a secret till it is not open to the public or open to anyone. And such type of trade secret, many times they are not even covered under IPR. But till it is a secret, it is benefited to the creator or inventor who is holding that secrecy with them. Now, latest in 2001 and 2005, plant variety, they are protected, which are dealing with agriculture, horticulture, sericulture, new inventions, and these newly developed crops and plants, they are protected under the plant variety. The layout design of semiconductors, ICs, integrated circuits, and all these things, these properties are right now protected under the intellectual property, and it is approved by the TRIPS. These properties we are looking in nut and shell in the following things. This is just industrial property, its types and copyright and related rights. All these industrial design, patent, trademark, service mark, trade secrets, geographical indicators, layout designs, plant varieties, all such types of things are now being protected very well. Initially, we have to look into the IP related laws and conventions also. There are certain conventions developed, and of that, it is just protected. Paris Convention initiated in 1883 for the protection of industrial property, which is giving protection to industrial property, trademark, patents, and governed by domestic legislations. It is followed by the Berne Convention in 1886, the protection for literary and artistic work. It is also governed by national legislation. And now, in the latest 1994 and 1995, TRIPS has also developed certain laws, rules, regulations, which are provided some additional norms to the Paris and Berne Convention of intellectual property. Another treaty, that is Patent Cooperation Treaty (PCT), has been developed, and this treaty is related to the international phase to national phase filing of applications at economic way. Because these patents, only if you file in your mother country or your own country or in a specific country, the rights of the monopoly will be received for that country only. But otherwise, that can be used in other countries, and hence, for this purpose, multiple patent filing, multiple country patent filing is also accepted. And PCT 2004 treaty, they are helping in filing the patents at different designated states in economical ways. Then, as we know, everyone, Copyright Act 1957 is in effect, and it is giving 70 years protection from the death of the creator, and it is constantly renewing. And latest one is also 2012 and 2016, which relates to the electronic resource protection or copyright for the digital resources, etc. Trademarks 1999. Earlier, this Trademarks Act was called as Trade and Mercantile Act, and it is effective from 1958. It is revised in 2000, and every 10 years it is renewed. Patent Act 1970, which is revised in 2005, and it protection for the intellectual property is for 20 years from the date of filing, and the patent assignee or the inventor is the owner till that time. Industrial Design Act 2000, it is for the development of different design which are aesthetic, and every 10 years they are renewed, but its validity is for 10 years. Geographical Indication Acts came into effect in 1999, revised in 2000, and its validity is also for 10 years. And its duration for the protection is 10 years, and again you can renew it till you feel it. Trade secret has no specific legislation because it is a confidential information residing with a creator, and as long as it is safe with his hand, there is no harm. But once it is leaked by anyone, then he may be in loss. So there is no specific legislation for this. Plant Varieties and Farmers' Right Act 2001, it is giving just due protection for newly generated plants, that is for 15 to 18 years, depending on the categories of plant. Semiconductor Integrated Circuit Layout Design Act came into practice in 2000, and it is also protecting the new inventions or new activities, new goods, new articles, new programs for 10 years, and it is also renewed after. 26 April every year is celebrated as World IP Day throughout the world. And this is giving respect, homage to the inventors who has invented new things and we society people, we are using for best of the aspect. So few organizations related to IP, we have to take care of this because they are always leading into this IPR or IP related aspects. WIPO, World Intellectual Property Organization, it is developed for giving protection of IP throughout the world, and its headquarters is Geneva, Switzerland. GATT, that is General Agreement on Tariffs and Trade, and it is a legal agreement between many countries whose overall purpose is to promote international trade by reducing trade barriers among different countries and fix the tariffs or quotas for import-export purposes. TRIPS, that is trade-related aspect of intellectual property rights, they are providing minimum set of rules and regulation for protection of intellectual property globally under WTO, that is World Trade Organization system. And World Trade Organization system is dealing with the rules of trade between different nations. These four organizations, they are looking into different aspects of IP creation, IP protection, and all these things. Now, the first property, intellectual property, coming out from the human brain, human mind, is patents. Patent deals with innovative products or processes. Patents are totally new innovative products, newly introduced in the market. Either it may be an article, it may be a machine, it may be a method of preparation of that machine, compound, mixtures, its process of preparing. Patents are treated as key to the knowledge. It is said that patent reading is definitely giving more benefits rather than any other literature. And the reason is that the content of the patent or the text of the patent or the knowledge base of the patent is not covered elsewhere in any of the published literature except patent. 80% of the data which is disclosed in the patent is not available, and that's why it is necessary to use patents in future for developing new concepts, new ideas. The main functions of patent system is that, first of all, it should have to give protection. Protection to the intellectual property which is generated by the human. A grant of patent allows patent holder to exclude all others from commercially exploiting the invention. Whatever invention is done by the creator or inventor, it is protected for certain period, and no one can come across in his area till he has some agreement with the others. And that's why the function of patent system is protection of the IP, and second is disclosure. Whatever new things have come into the market, that should be disclosed to the public openly, so that the knowledge what is embedded in that patent will be used by others, and it will be a stimulus for them to just develop new ideas, create new inventions, new innovative ideas, concepts, and contribute to the economic growth of the country. So these two main functions of patent system, that is protection of the IP and disclosure of the IP to the users openly, so that they can use it for their future research. Now, if we took an overview of the patent, then the word patent is derived from the Latin word pater. That is means to lay open. make available for the public inspection. And just now we have seen that protection and disclosure, they are the two basic things. Here, the patent means open to public. Anybody can read that and try to see that how best we can work on that, and we can modify that, and we can generate ideas, new concepts from that, which may be useful to the society and which will help in developing new products. Then literary patentes means open letter with royal seal. It is a certification given by a state government, which is called as also a royal degree granting exclusive right to a person who has invented new creations. Those who have created invention and that is found new by the patent offices, then patent office by means of government patent through patent office, they issue a grant of letter for giving protection to his invention for a particular period, that is 20 years from the filing date. So patent grant rights to inventor for developing any device. These patent rights are given to the any creator, any inventor who are generating, who are creating new devices, substances, method or process of their preparation, which is, but it should be new one. Nobody should knew it. It should have an inventive step either, but it should be very useful to the society as in general. We are going to see these four factors in the following slides. For patent protection in a country, it is always necessary to apply to a patent office in the country. Wherever you apply the patent, if it is granted for the novelty, then you will get a certificate and you can have a monopoly on that invention till its expiry of the day. So this patent office, every country has a patent office. Similarly, the countries wherever protection is required, you have to apply individually to that country, and that is called as multiple patent filing. Suppose, for example, I have prepared one new product which is new and I filed a patent, I grant a patent also, but I will get its monopoly rights in India only because it is a territorial protection. And that's why if I feel that other countries can also use this research or a product invention, then I will be get lost. So basically, the purpose is that I have to file patent on the same topic, same invention to America, France, Japan, China, whosoever may be the competitors for your invention. And this is very important thing that we can also find out importance of patent based on how many countries that patent is filed by that inventor. If it is filed only in India, its importance is for Indian territory only. But it is filed in more than one country, then of course the invention is very powerful. It can be useful to everyone, and that's why the inventor has protected in different countries. Right now, United States, USPTO, many inventors, they go and file patent there because USA is the largest hub of the business, and that's why every creator want to develop a protection in United States and English-speaking countries by applying to each and every country wherever it is possible. And WIPO, they are assisting in directing the patent filing in respective countries through PCT, EPO, or REPO treaties. Currently, around more than 198 patent offices are spread worldwide. In fact, I will say that every country has its patent office as well as its own patent law. Every country has decided that these are the inventive areas in our area, and that is specifically mentioned in the patent law of that country. Every country has its own patent law. Indian patent law, United Kingdom, UK, USA, every country has. So they are fixed their boundaries for that, and if it is approved in that patent law, then you can get your novelty search and novelty uh, invention being protected there also. Nearly more than 6 lakh patents are granted or added worldwide every year in all fields of knowledge in the world. So a huge intellectual property is coming out throughout the world, and it is now definitely to take a note of such type of properties, how we can just protect whatever new inventive ideas we are coming. Now, how these new ideas are coming into the mind? It is not coming all of a sudden. Of course, maybe, but very rarely. But your work experience, work knowledge, and continuous experimentation on a particular idea will bring out new idea, and that new idea will turn into invention. And such type of invention are nothing but any new and useful process or method or machine or apparatus, article of manufacture, or even improvement in any existing product, any existing atom, article which is not known to anyone, and such type of new ideas are being patented by this property. So ideas develop into mind by way of reading lot of literature in the expertise areas. Then when you generate ideas, then you work on that, then you have some innovative concept developed out of that. And these innovative concepts, when we experiment in continuously, after doing experimentation and all that thing, then you come to a certain new clues which leads to the invention, and such inventions are being protected by the patents. An invention is described as a new solution to any technical problem. If you have certain technical problem with you, then the first solution is given by the patent literature. And hence now many scientists, R&D people, scholars, they are turning toward the patent literature. Whatever area it may be, there are patents, and anybody can refer to this patent, read this patent free of charge. Every patent office have put their treasure of patent literature open to public, so that new and new innovative concepts should be developed and they should come forward, and our technology transfer will take a great lead into the society. The problem may be old or even new also. There is no need that old problem only will do or new problem will be due. Problem may be anything, old or new, but the solution provided to that is in order of merit. In order of merit means it must be a new one which is not known to the users previously. And that's why the routes, different routes and different preparation methods, they are also coming under the process patents. So when you are filing the patent, that is called as the priority date. That date is fixed for getting you the patent. Now we will look into this thing. Who are the best users of the patents? Almost all everybody has to use the patent, because the patent is embedded with the multiple aspect of the knowledge. Say for example, R&D users are users from industry, they are using right from the beginning. Different research organizations, researchers, government authorities, small and medium scale, large scale entrepreneurs, enterprises, industries, or even individual inventors, they are also using patented literature for various reasons. Either they want to learn from patent literature, what is new in our area, what has happened before, what I am thinking on this issue, all such type of thing. This R&D user are connected with this. There is another one group of this, that is different professionals are also involved in the intellectual property field, like administrator of technical libraries like Dr. Shanti Shri Sengupta, what I work for my organization. Then there are patent agents are there. Those who cannot draft the patent, patent drafting is the main art, main skill while filing the patent to the patent office. When you generate new idea, the ideas to be put on the paper, because you have to put in systematic way. You have to compare what happened in the past and what newness you have brought into that product. That is to be mentioned systematically, and we can orally tell to the lawyers or patent agent, and patent agent being an expertise in patent writing, patent drafting, they help the researcher in drafting the patent and filing to the patent office. So patent agents are also users of the patent. They are also act as this patent agent, also act as a consultant, advisor to many industries. No, you start this product because this is the future generation product and you have to work on this so that you will get some benefits in future. Then there are producers of databases and data banks also. They are also coming into this because they have to protect their databases with the licensing. Then all educational institute and university student and professors are also using patent because they are also the creator of the new invention. They are also generating new ideas because at the college level, university level, PG level, all the research centers are developed. Their R&D work is going on. Even many colleges like Modern College, they are having a good relation with the industries, and industry and college collaboration, they are acting for the developing innovative ideas, and such type of things are coming out into the educational sector also. Then information brokers like information agent, patent searcher, information searcher, which is played the role by the librarians also. There are many patent analyzers also, patent watcher also. They are also using patent literature because based on the existing literature or based on the existing invention which is reported in the patent form, the analyzer will analyze and draw a panoramic picture and find out which are the gaps in the research. And these gaps in the research, they will act as a consultant, technical expert to different organizations, industries, and they will just guide them which are the future products in the market and how you can proceed for that. Even there are many forecasters, fortune tellers, forecasters. They are also good planners. Patent examiners are also there. Patent examiner, they are working with the patent offices and granted your novelties from the patents. So all these users of the patents are very important. And of course, now a big sale of patent sale is coming out. And many expertise. Now I have seen that almost all industries have their patent cells. Means those who are subject expert, having good knowledge of IPR and IP and how to protect IP, will have definitely a good chance in industries, in even their own career development, like patent agent, patent attorney, patent examiner, patent planner, patent analyzer, whatever may be, or act as a consultant. So society in general also benefited by the patents also, because if new and new patents are Every day we are looking into the aspect. Now, what is exact patent? WIPO defined patents as an exclusive right given for an invention. Somebody is inventing new idea which is not known, which is non-obvious, which is not recorded anywhere, and such exclusive rights are being granted by the patent offices which appointed by the government or state, and which gives new ways of preparing and providing solution to new problems. And such concepts are being protected, and the document in which they are described and get patent is called as a patent. So it is a simple thing. It is a patent is nothing but an exclusive right given by government to the inventor for inventing new invention which is non-obvious, not known to the users or even society. Right now, as we have seen, the Patent Act 1970 is in effect, which is revised in 2005. A patent is the agreement. It is also called as an agreement between the inventor and the country. They have mutually understood both of them, and country award him patent because for his further sustenance and further growth in the knowledge. Country is also benefited because the technology transfer can be done, which permits the owner to exclude this. What patent gives rights? They exclude all others from making the same product or machine or process, using that process, selling it, or you can claim that invention for specific period, that is 20 years from date of filing, and after that it will come to the public domain, which anyone can use it without the permission of that, but only we have to take a reference as a prior art into the patent literature somewhere. So patent rights protected are territorial. I have just told you just before, Indian patent rights does not confer any rights outside India. It will be reside in India. But if you want to acquire the rights in USA, then you have to apply the patent in US country as per their patent law and their system of patent filing. Filing of patent application to patent office is mandatory. It is not an automatic process like copyright. You have to apply to any patent office wherever you want to get monopoly rights for your invention. It is not at all automatic. After submission the patent to the patent office, patent attorney, patent examiners seriously look into the novelty, and then they grant the patent. So any person, even if he is minor, major, educator, literate, illiterate, professional, non-professional, they can apply for patent. They can either alone they can apply, or they can join hands with the company or any other joint venture, and they can file the patent as assignee. It may be educational institute, it may be a company, it may be a other person. The reason is that filing patent and granting patent, we have to spend some amount on that. It is in India right now, it is ranging between 1 to 2 lakh, whereas the US patent approximately it is going to 3 to 5 lakhs like that. So if anybody has a new idea, but he cannot file a patent because of the monetary paucity, then they can approach to institute, any company or anybody who can just share the finance, and only thing is that inventor will be the creator and assignee will be the second in the steps. So any patent gets lapsed. When patent gets lapsed, two ways. After 20 years, it will lapse automatically. And second thing, if you have not paid the patent fees properly, patent fees is like a renewal of license. You have to renew it after your expiry. Similarly, for example, I will tell you here, I have filed a patent, I granted a patent, but I paid the patent fees for 5 years. Then I thought that nobody has approached to me. Then why shall I just renew my file, my patent? Then I have not renewed it. But later on, my friend came and asked, your patent is seeing lapsing. You have not renewed it. Why not to renew it? Because that is containing very good innovative concepts. Then again after 6 months, I am paying the fees. But what happens? This patent watcher, patent analyzer, patent agents, they are watching the properties, whatever inventions have been filed and which are getting debarred from the protection. As soon as within these 6 months, if my invention is very popular and very impactful, then anybody can just take the benefit of that and start producing the compound or manufacturing the machine. We cannot say anything. This is called as window period. In window period, you may lose everything. That's why your patent should not get lapsed unless and until you are very much sure that it is not going to be monetary benefited in nearer future. That is the concept behind this. Then what are the rights of a patent holder? When patent is granted and patent is in your hand, then what are the rights owner gets? They describes who decides who may or may not exploit the protection invention. Means it is on the inventor to whom he has to share his invention. Either he can use himself, he can share with institute, he can share with organization, or he can outright make some MOU and just share with the industry to just prepare that product like pharma drugs. Then using some MOU and licensing, they can work on such type of thing. So, but when patent is in public domain, then there is no need of making any MOU. Straightway, anybody can use it. Patent document varies from few pages to hundreds of pages, depending on what you are protecting. Especially engineering drawings, engineering patents, which contains engineering drawing, they take lot of pages. But wherever pure scientific, basic applied research patents, they take shelter of original theory and just file. But the patent document is an important document for study to all users of the patent. And patent document is a very unique document which covers only the description of scientific method, how it is done. It gives technical data. It narrates practical concept into that, and which are in detail. But even if these details are available into that, no one can directly go and produce the product immediately because they are given in the average values, ranging values. Process parameters are given in temperature between this and all these things. Variety of combination have been given to that, and it will take some time to develop R&D and fix the nomenclature for that. But by that time, what happens? Many new patents come into that area, and that patent becomes obsolete, and new products came into the market. And that's why nobody try to get copying patent. After say 20 years, they will think for if something is novel, then they can take the process and go ahead for that. The structure of the patent document is also unique. They have given specific structure. That structure is universally accepted, and they are using certain codes which are called as INID code. INID code means internationally agreed number for the identification of bibliographic data. Say, for example, I want to browse only title of the patents in my area. Then if I go and click on the 30 item number, all the titles will flush on that. Or even deals with technical data. If I will go in the 51 section, all the technical data about the innovative idea are described into this. So IPC classification, inventor, assignee, prior art, everything has a unique code given, that is unit code given, and if you go and directly hit on that code, you will get the data related to that code only. It will not mislead anything else. So this is very good for the researcher in quick browsing the browsing patent literature, what is happening into his area. The information disclosed in patent is in detail actually. It is given, title is given, what is the title of invention, a brief abstract is given, references to prior art, what is happened before, that is called as background research, is totally given under the prior art, and even that is given under the description, and complete technical description, how he has prepared that product, or prepared that process for production of that product, so and so, with drawing, diagrams, figures. They are given in detail into that, and claims are also provided, and these claims are very, very important into the patent, because this claim sets monopoly rights for your invention. If they are new, then only you will get the patent. Otherwise, if they are already available in the prior art search, then they will decline the patent granting process. There is no world or global patent. There is no world or global patent. Once you file there, it will take a monopoly everywhere. No, it is not there. But only world application is there. And taking the base of this world application, you can file the patent in designated countries for the protection. Easy access to patent information using several searching approaches. You can search the patent literature with lot of accessing points, right from you take inventor, keyword, even classification number, which is unique international patent classification, and the expert only search by this IPC number. Then subject or any important element you find, because nowadays free text searching is also permitted in the full text databases, even bibliographic databases. The terms which are not indexed, they can be also identified, though it takes some time, but you will get certain information on that area. All the countries have developed patent databases for searching patent on required subject. Every national patent national national countries, or every country, they have their patent offices. They publish their national database of patents, which is free to everyone for searching. You can search, especially we can see some sites further. The full disclosure of patented invention is mandatory. In patent document, you have to give full disclosure to it so that your patent cannot be turned down. Otherwise, what happens if you hide something and somebody has placed that point in his patent, then prior art search, or if it is known public, then you will not get patent into that. So many times what happens in the thesis, whatever we prepare a compound, and then if we go and file a patent for that compound which is already documented in your thesis, the patent generally not getting granted. That's why while preparing or while uploading the thesis, many more precautions are to be taken, in especially when you are loading into the institutional repositories and all these things. The importance of patent lies because patent is excellent source of technical information, scientific information, professional information, which is directly related to generating new knowledge. More than 80% information covered in patent is not disclosed anywhere in other publication. And that's why what happens, the researcher and scholars, they are just browsing continuous patents. Patents only gives you the rights for 20 years if it is granted. Any entrepreneur or any industrialist is looking for the granted patent because the granted patent covers technology which is acceptable and there is no fear of infringement in later stages. Patents are used to identify expert. Who are the expert in that field? They are helping into that. Innovators and manufacturing companies in a particular area, who are the innovators. So inventor can approach them or company can approach to the inventor, vice versa. So they mutually get benefit. Then detailed description and the claim indicate new invention report into the patent, a unique source of technical information, and that's why patent is very important aspect. Types of patent, there are mainly three types of patent: utility patent, plant patent, and design patent. Utility patent covers process and product patent, which are mainly dealing with the area of chemical sciences, electrical engineering, mechanical engineering, even computer engineering. Product patents and process patents are covered under the utility patent. Plant patents are now given rights to the variety of plants for their colors, for new plants grown by the farmers, agriculturists. This is the new property development. Then design patent, whatever skilled person or even a knowledgeable person has created new ornamental design, article design, article of manufacture, even which is looking very appealing to the eye, and such type of designs are covered under the design patent. There are three possible routes for filing the patent. One is national route, another is regional route, like EPO, PCT, ARIPO in particular European countries. International routes, filing at PCT. So in three ways you can file the patents. Our own country, particular region for covering the protection, and at international level it can be possible. Now, when you file a new idea into the patent office, before that you have to see that whether our criteria for patentability is fixing or not. Whatever criteria is required for granting a patent are fulfilled by our invention or new idea is there or not. There are 5 to 6 consideration taken for the patent while granting the patent. First of all, whatever invention or whatever idea, whatever product, whatever machinery, whatever article you have developed, it should be totally new, novel, novelty in invention, original invention, which is first time of its kind in the society, and such type of new concept, new ideas are being patented. They must be new, not anticipated by prior art, that is not available in any form of information. We will look this point further. Second point is that it should have a usefulness, capable of industrial applications. Invention must be workable also, capable of industrial application. It must have a practical use, and utility or usefulness is at higher level. If patents are not useful, then who will look into that? No one. And that's why even if new ideas are there, but they are not useful to the society, it is not worth for filing the patent because we are filing the patent for getting certain benefit out of our innovative ideas. None are not obvious, not known to anyone, published anything on that concept before, the same product or process before in any kind of literature. Whatever product or process or whatever new element you have dragged, it should not be discussed anywhere in any written form, in any form of publication, that is book, periodical, thesis, patent, conference proceeding, reports, seminars, whatever may be. But it should, even if suppose today I told you I am filing a patent on such and such a innovative idea, which is very useful, and I filed a patent on that, patent office granted the patent, but later on, one of you may raise a point that this gentleman has declared that this invention I am going to file. So this I know, and all the community present on that day for the webinar, they know it, and hence it is not a, it is a coming under the prior art. It is not a new thing which we know. And that is why many times, based on such claims, patent office deny the grant of patent also. Further, one more point is that patentable subject matter. In whichever country you are filing the invention, that invention subject matter should be acceptable by the Patent Act of that country. That is mandatory. Then inventive step, not all the way new only, but existing product. If you develop a new inventive step into that, you added a new inventive element into that, which nobody has known so far, that can be also, that only that part, only that phase can be patented by the inventors. So these are the 5 criteria basically patent office look into while giving the patent. And these we have to follow: newness, usefulness, non-obviousness, patentable subject matter, and inventive step. These are the 5 criteria. Then what is not patentable? Whatever ideas protected by other industrial properties, they are not protected here. We will look one by one. Discoveries, principles, scientific theories, mathematical model, business methods. Their provision is under the Copyright Act. But you take the basis of this and you develop certain application on that, some new element into that, or goods or process into that, definitely that can be patentable. Aesthetic creation, that is beautification, modernization, appealing to the eye, looking nice. These are covered under industrial design. Computer programs, earlier they were covered totally under the copyright, but right now, few countries, they are granting patent, including India. And that's why our Indian contribution in IT patent filing has been enormously increased, and we are coming in first 10 countries in the world right now. Then medical procedure, then method of treatment, like diagnosis, surgical treatment, for human or animals, it is not coming into this. Invention contrary to public order, like mortality, public health and safety, principle of humanity, environmental conservation, all such type of things are not covered under patent. Simple rearrangement and duplication of devices are not patented. New method of agriculture, horticulture, like medical procedure, not patented. Methods of doing business, for example, method of bookkeeping, trading stocks, these are also not patentable. Presentation of information and scheme of plans are not patented. They are going to copyright. Frivolous claims means trivial claims. Okay, we will claim and just we will say something careless claims we are putting and just filing. It will not be accepted. Contrary means opposite to the well-established natural law. These are not patented. So such criteria have been fixed for granting patent and non-granting patents. So benefits of patent to each and every one, of course. Inventor, they just avoid duplication. They will spend their time in qualitative innovation. Then society, they get newer and better product at economic rate. Researcher, again they are avoiding duplicate, and they will get the complete state of art progress in that subject area, and the researcher can be benefited in selecting the gap in research and work on that. Patent agents, as we have discussed, that they are helping you in patentability, whether it can be patentable, it can be possible to file a patent, they can guide you, coach you, they can draft a patent, they can help you in filing the patent, they can just conduct opposition search, revocation search, or validity search. Many searches are related to this, they can be searched into that. Consultant and planners are also there, they are also benefited. So such things are there, and these are most essential benefits. What even industries and organizations, they are benefited because they are getting more and more new products. They are getting some patented products for negotiation and developing new market in the society. All such type of benefits are coming into this. Then obtaining patents in foreign countries, we have to just apply them, that we have seen. To obtain patent protection abroad, the inventor must file and prosecute a patent application in each foreign country wherever we want to get protection, and it should be acceptable by the country's patent law also. There is no one international patent, or there is no world patent. we have to just file the patent in each country wherever you want the protection. Why search patent information now? Why we have to just go and search the patent information? First of all, knowledge about the state of art. What is going in our subject area? What is the till moment development carries in my subject area? A panoramic view can be analyzed, and based on that thing, a new area or new direction can be noticed for the new generation of knowledge. Assessment of novelty and patentability. We can find out whether our product or our process or our article is novel, can be patented, that can be fixed by searching information. Evaluation of specific technology and identification of possible licensor. If I am not the creator of information, I am not the creator of knowledge, but I have a finance with me, I can just license out some inventions, I can produce it and sold it in market, getting MOU between the creator and myself or industrialist. Identification of alternate technology. If this route is very costly, if I cannot go by this route, can I go with another route and find out the solution for that? So alternate technology assessment, patent literature search or patent information search is essential to find improvement in existing product or process. Product and process both are existing, but I want to do something more into that and I want to add some parameters so the production cost will come down and the production will be enhanced. Monitoring of activities of competitors both within and outside the country, because here you can monitor the competitors. That is more important. If somebody is doing X product, then how I can come out with the better that product in the market, which will get more and more popularity. So such type of thing only we can get from the patent searching. And that is why people or researcher or any common man, they are who are having innovative concept generation, they can just follow the patent literature. Okay. Then while searching, if you want to search patent, there are commercial patent databases available. Then some free patent bases are available. For commercial databases, it is very essential to go when you are filing a patent in the patent office. That time, using these free patent databases, the work will not be sufficient, because these commercial databases are specifically meant with proper structured data which can be searched with the direct need of the researcher. Say example, Marcus patent database is directly searching claims so far filed in the chemical patents, and that's why the claim what you are claiming, if you search for that claim, at least 4 or 5 patents will be given, and then you can draft your patent claim according to get the patent granted from the patent office. But we cannot deny the use of free patent databases, because free patent databases, they give you inertia or initiation to start the research work, to think in a different way, and this different way will lead to the inventive step. And that's why it is said that why not to search literature from these free databases on your particular topic of interest, or your new idea come into your mind and brain, and then apply it into this and you search some information. I have given certain sites for that. Even in leisure, you people can just work on that. Patent information can be searched in variety of ways. Say, for example, you can search by any subject, any general subject, any specific subject, any keyword related to your topic of research, your subject of interest. Then patent classification, international patent classification, very important. You can search with the international patent classification, and searching with international patent classification with text keyword and subject will give galvanize a less number of hits which are directly related to your search. Then inventor search, assignee search, publication date search, then patent family search, legal search, chemical substance search, then proximity search, chemical structure search, then country-wise patent search, where what things are going. All these you can search by variety of access points based on your need of the research, and that is why such a glorious document, if you can start reading, I think many educators and students, they definitely just be a good patent filer. And many times when we read in the newspaper that College of Engineering so and so have developed, filed a patent for such a uh, uh, new car model, car running on solar cells and LEDs and all such type of thing are coming out. So there are different type of patent searches that we will not take into consideration right now. But you should have, and these searches are basically conducted for filing the patent at the appropriate point to judge the patentability issues, and then file the patent into the patent office for granting the patent of your novelty. How patent flow is going on? You have to read and scan and evaluate patent literature or any literature from any sources. And then what happens? By reading all such type of literature in your particular area, in your particular discipline, in your concentrated subject, then you can just have something new after reading and compilation of all the ideas generated by others and presented in different forms. You compile them and find, if I can do like this, then what happens? And if you just make experimentation on such type of innovative ideas, then invention is created. And such type of invention, you have to search for the prior art, whether it is published or available somewhere. If it is available, then take the alternate route. If it is not available in the prior art, then go for the patent filing. That is the easiest way for that. Then after filing the patent, there are, as I told you, national route is there, then regional route is there, international route is there, and that you can follow and file a patent wherever you are likely to expect to get the monopoly rights. Then patent offices will give you application number. After that, examination of your patentability aspect, with that 5 points will be taken into consideration by patent examiner, and they will be examined. And if you are through from the all processes, then your patent is granted. Then it is announced in the Gazette of India, and then you will get the licensing authority for the patent. These are the general steps which are followed into that. If you look into the patent filing area, patent filing in India, the trend is rising trend. If you mark, we have just added this slide, because if you have just cursory look out into that, you will find that the patent applications are increasing, then design applications are increasing, even geographical indications are also increasing. So you will find the trend, and now you will find that many educational R&D organization in the sphere of government, public sector, they are also filing more and more patent, like CSR is there, DRDO is there, research labs are there, research centers are there. ICAR is filing the patent, then ISRO is filing the patent. More and more areas you found are mechanical, chemical, computer and electronics, electrical engineering, drugs, chemicals, pharmaceuticals, biotechnology, genetic engineering, food, and there are many other areas where India is filing patents into that. So almost every area of the knowledge, patents can be filed. If you calculate the state-wise, Maharashtra state is in leading position, then followed by Tamil Nadu, Karnataka. But this status is changing every year. It doesn't mean that the particular state will be on top, but that is the just analytical part of that. Then if you look into the global patent ranking analysis, a cursory analysis of patent application, if you look, for the first top 10 countries in 2000, then they were USA, Japan, Germany, France, Republic of Korea, United States Kingdom, Italy, Russia, Federation of Netherlands, Australia, China. India was not in their list earlier. But in 2014, among top 10 countries were China, United States, Japan, South Korea, and India is among that. We are leading at 7th position because we are now aware of filing. Even university people, public research institutes, all they are now aware of filing, of protecting intellectual property, and now it is a very good moment that we are coming into that. In 2018, if you look into that, our patent filing process is increasing, and still we are maintaining our position. Since 2005, India initiated patent filing more due to changing IPR status throughout the world. Especially Indian Institute of Science, Bangalore, CSIR, IITs, even engineering colleges, prominent universities, MIT University, then even Flame University, they have filed so many patents in this area. And if you take a cursory trend in the patent filing, you will find that 5 patent offices like United States, Canadian Intellectual Property Office, European Patent Office, Japanese Patent Office, then WIPO and Chinese Patent Office, they are leading among the patent filing countries in the world. Okay. Now, I have just cited certain examples for you that how patents, in which areas of commerce and business patents are being filed. See, I have given number also, reference number also there in that. Methods and apparatus for advertising on mobile gaming, sport devices, sport racket and racket handles, wedding ring jewelry, wood cutting apparatus, method and device for production of wood sheets, advertising techniques, interactive advertising, sports shoe, particularly for cycling. See, many sport pants, then musical instruments, you can just file patents in any area. So one example have been given in Jaipur, drawing inspiration from the scientist, that is Hawkins, Stephen Hawkins, a wheelchair-bound 9-year-old boy. He has designed a model for the 6-player chess, circular chess, and it is design patented. Means you have certain ideas which can lead to invention, and invention can lead to the protection. There are certain things like pen with scanner. Now new things have come, pen and scanner in one. So while writing also, you can scan that script also. Rubber shoe for horses are giving for the health purpose. Instead of iron shoes, rubber shoes are used so that horse cannot get injuries to his feet. Then packaging success they are getting. Now packaging industry, they are using paper because plastic is banned many countries, and this is coming. Then life-saving inventions are coming. Volvo's safety department, they have bring 3-point seat belt for the driver, which gives you the benefit of the protection from the hazardous events happen during the driving, all such type of things like airbags and all these things, they are coming out into that. There are different patent offices located in India. There are regional offices and main offices at Calcutta. Then their jurisdiction is given into this slide also. There are certain patent agents are also there, patent attorneys, trainers are also there. Many institutes, they are taking courses for such type of things that I have mentioned. But Nalsar University is giving, which is a law university, which is giving 1-year certificate course, 1-year degree course for patent filing and IPR related issues.